If you think having a will is enough to protect your assets, you might be missing half the picture. A will controls what happens after you die. A trust can protect your assets while you're alive. Most people have heard of a will, of course, but few understand how trusts work, and they can be just as important. People understand how trusts work in tax planning situations, but not how testamentary trusts work at all. Hi, I'm Jaswinder, Senior Lawyer at Goldman Lawyers and the Managing Director in Australia, an international and Australian law firm. And today I'm speaking with Kerry Turner to explain the key differences between a will and a trust, and the types of trusts you can have, both under Australian law, and when you should be using a will or when you should be using a trust.
What is the difference between a will and a trust?
Thank you, Kerry, for that question. A will is a legal document that sets out who gets your assets, who manages your estate, i.e. your executor, and what happens after you pass away. But here's the key point. A will only takes effect after your death, and it usually requires us to go to court to get probate, to validate the will before assets are distributed. A trust, on the other hand, is a legal structure where you devise or gift assets to this trust structure to be held by a trustee for the benefit of beneficiaries, but a trust can operate during your lifetime. So it allows for ongoing control, asset protection, flexibility in distribution, and maybe some tax savings. But here's a simple way to understand it. A will takes effect after death, requires probate, can be challenged, family provision claims. It's simpler and lower cost. A trust can operate during your lifetime, may avoid probate because you've gifted everything anyway. It offers asset protection, it's more complex, has other advantages, but it's a lot more powerful. So you generally need a will if you want to legally distribute your estate and you want to appoint guardians for your children. You should consider a trust, though, if you want asset protection, have a business or significant wealth, and you want to control how beneficiaries receive the money. You want to minimize disputes between an extended family. So the best strategy is to use both together. And how do you do that? Well, you can actually set up a trust through your will. So the biggest mistakes I see are that thinking a will avoid disputes, not updating your will after major life changes, setting up a trust incorrectly, or not understanding the tax and control implications of setting up a trust during your lifetime. And importantly, a poorly structured estate plan can create more problems than it solves. In Australia, estate disputes are increasing, especially with blended families and rising asset values. And that's why more clients are moving towards structured estate planning, not just basic wills for $200. A will decides where your assets go after you die, but a trust decides how they're protected and when the beneficiaries can have them. For example, they might only have the assets after they're 21 or 30. Might protect them from marriage disputes or de facto disputes as well. So the right structure isn't just about passing on wealth, it's about protecting wealth. So if you're thinking about your estate planning, we offer a confidential consultation where a senior lawyer reviews the situation and outlines the best structure for you.